Everyone, and welcome. Thank you for joining our CE webinar today to talk about private practice and risk management during COVID-19 with NASW Assurance Services. My name is Michaela. I'm the Special Projects Coordinator, and I will be moderating the webinar this afternoon. Just to go over a few housekeeping items, if you have any difficulties with the online or audio portion of this webinar, please make sure you have entered your audio PIN, your computer speakers are on, and you have a strong internet connection. You should be able to see our presenters' PowerPoint slides if you're on a computer. Or do we have a PowerPoint?
No, we're not going to have a PowerPoint today.
I will skip that part. Attendee phone lines are automatically muted and will remain disabled for the duration of the program, so don't worry if you have any background noise going on. However, we want this to be interactive, so if you have any comments or questions, please post them in the Q&A questions tab on your RingCentral control panel. We will stop at various intervals to answer any questions about the material, but we will also take questions at the end of the presentation. We may not be able to get to all of the questions due to the number of people registered, but we'll try our best to answer as many as possible. And just a side note that you'll be getting your CEUs emailed to you by Tuesday. Annie, you can take it away.
Thank you so much, Michaela. Welcome, everyone. My name is Annie Siegel, and I'm the Continuing Education and Membership Coordinator for the National Association of Social Workers, New Jersey chapter. I'm joined here today by some wonderful presenters from NASW Assurance Services, including Betsy Cauble, Dina Larson, and Lonnie Ropp. We're going to talk to you a bit about risk management and how to navigate that with your private practice amid COVID-19, and I'll just be helping moderate and fielding questions, but please take it away, Betsy.
Hi, I'm Betsy Cauble. I'm delighted to be back here and working with the New Jersey chapter. I think I did a technology and social work practice presentation a couple of years ago at the New Jersey conference. People were enthusiastic, and you have a great group of social workers in New Jersey. I want to apologize a little bit. I'm having a terrible time with spring allergies. So if you hear me coughing and things like that, it is not COVID-19. It's a lifelong allergy. So first, I want to say a big thank you to all of you out there who are engaging and shifting your practice so you can serve clients in this really difficult time. We all know that isolation is about the worst thing that can happen for people who have mental health issues, domestic violence issues, child abuse issues, elder abuse issues, all those things. And you're stepping up to try to serve that population while you too are dealing with the anxiety and isolation that this pandemic has brought us. So I was asked to kind of talk about what would be the best advice that I could give you. So what I want to start with is, please remember to practice self-care. That because you're experiencing all the same issues, which is kind of unusual for us to be experiencing the same thing our clients are at the same time, it's tough for you too. So please take care of yourselves because of how badly we need your expertise at this very difficult time. I also wanted to share that I think the best news is, for those of you who are wading into the telehealth world for the first time, or teletherapy, whatever you're calling it, that there are a lot of resources available to help your transition to doing online or on-phone therapeutic interventions. Those things include, first of all, our Code of Ethics, which has always been the map for best practice in social work for a long, long time. And a couple of years ago, the Code of Ethics was updated to include the new technology standards that a bunch of smart people figured out that we would need several years ago. So we have technology standards for social work practice that were produced by the National Association of Social Work, the Council on Social Work Education, the Association of Social Work Boards, and the Clinical Social Workers Organization. Those are available to you. In addition, we have a webinar on the NASW Continuing Education site that takes those technology standards and drills down to help you understand technology and social work practice. Also, the NASW Assurance Services, who is the producer of many of your insurance policies, has produced a series of podcasts. How to reach all those resources will be distributed to you post this webinar. Correct, Annie? Did I get that right? Okay. So as we think about how to go forward, both to provide best services to your clients, but also to protect you from risk, because all social work practice has some risk involved in it. I want to also have you think about the things that the Code of Ethics outlines to really help with this kind of thing. And the first one to think about is your informed consent. And what kind of informed consent are you constructing to provide to your clients so they know what to expect and for you to mitigate risk? And there are a lot of new things to think about, because although technology offers this wonderful opportunity to continue to serve your clients, it is also fraught with a lot of surprises and difficulties. From my observation and the things that we've talked about with technology, one of the biggest risks is breach of confidentiality. There are hackers out there, no phone is really secure, all those kinds of things. So utilizing a good informed consent with your clients is the best protection for you and them. Many social workers have asked the last couple of years about how do we even go about constructing this? And assurance services, with their team of people and the lawyers that they work with, constructed an informed consent policy that you can take a look at on their COVID-19 website. Again, that information will be provided to you post this webinar. But that gives you a great place to start, and it has been reviewed by attorneys and the insurance bureaus as well. However, I want to say a caveat. Be cautious, because every state in the union has a different set of regulations, and you want to make sure that your informed consent policy conforms with your state's regulation. That's a really important thing to think about. And the other piece that's most important for you, in addition to informed consent, is documentation. That protects you and your client. So think about, how do you do an informed consent if you're talking with someone like we're talking today, over a video conferencing system or a telephone? Well, you first talk to them verbally and explain the informed consent and get their permission to go forward. Given that, you need to immediately document in your record the date, the time, and the location of that informed consent. If in the event you have a breach and you get sued, the first thing the attorneys are going to want to look at is your informed consent and your documentation. So it's really important to think about how you do that. Now, that's not enough, though. You still need to get it in paper. So how can you do that? Well, there are all kinds of ways you can do that. You can mail it to them. Should you do that, I would suggest you add a self-addressed stamped envelope for them to mail it back to you once they read and sign it. If they have access to printers and things like that, you could send it to them electronically and have them print it out and sign it and mail it back to you. But think through how you're going to do that before you start, so that you're protected from the very beginning and your clients know what to expect, because that will help with some of their anxiety as you go forward in this kind of new environment for them and you. The other thing about telehealth that's a little difficult right now, because many of us don't have many choices except to do telehealth, is that not all clients are really appropriate for this kind of intervention. You may have a client who has cognitive impairment and could not remotely be able to operate this kind of platform or run their computer. Or perhaps somebody who is nonverbal and it's more difficult for them to communicate in this way. So that is kind of an important assessment that you're going to have to do early on. And the last thing I want to say, I also think one of the hardest things about engaging in this kind of activity is that you cannot really assure confidentiality. You can ask your client if their room is secure and if they're the only people there, but you personally cannot see into that household or area and know whether or not other people can overhear your interactions. So it's important to make sure, again, that that's clear in your informed consent, that you cannot guarantee confidentiality in that way. You have to trust your client to a certain degree and ask them if they're in a secure location. And then again, make sure you document that conversation so they know whether, so you can attest, should the worst thing happen, that you have done that due diligence. So I'm going to start talking now because I know you all want to spend a lot of time asking questions, and pass it on to Dina so she can talk to you a little bit more about all these issues. And I'm going to let Dina introduce herself.
Thank you, Betsy. If for some of you, you may have spoken with me before, you don't realize it, but if you have tapped into the NASW Risk Management Hotline, my voice might be very familiar to you. I have spoken with a lot of social workers across the country. The company that I work for, Western Litigation, has partnered with NASW Assurance Services to provide that risk management hotline. We've been at it now for about 8.5 years. And I have spoken with a lot of social workers across the country on risk management issues. So that's where I come from. And for my introduction piece, I would like to echo exactly what Betsy said, that it's important to be aware of the regulations around what you're doing. You want to tap into the NASW Code of Ethics. You want to tap into the technology standards that are out there for you to use. You want to be aware of what your state regulations are for your license, whether they allow teletherapy, whether they will allow things if you have a client that's stranded in another state and you're not licensed there. How do you help that person? You need to have answers to these questions. Ideally, you would have eased your way into teletherapy if you wanted to start that. We all got kind of dropped into it. Normally, this is not the way you'd be having these presentations. You would be sitting in a ballroom and we might be standing up in front of you. That's not possible right now. So we're doing the very best we can with what we have to work with. So again, just to echo what Betsy said, documentation is my thing. That is, your documentation can save you or can hang you. And you want to make sure that your documentation with your teletherapy clients this is not the time to be vague. You want detail. Every time you have a session with a teletherapy client, the first question you ask should be, where are you physically located? Are you at home? Are you in the living room at your home? And when you have that information, put it in your notes. The reason that it's so important that you know where your client is just in case your client becomes critical, goes into crisis. You want to be able to get that client help. And you might be thinking, well, my clients don't have a crisis. They're just tune-up people, as I call them. What if that client has a heart attack while you're doing this kind of an exchange? And you're the only person who knows. You need to be able to get in touch with 911 and tell someone where to go to get to that client to help them out. It is critical that you know where your client is. And again, echoing what Betsy said, confidentiality, you cannot guarantee it. You certainly can't guarantee it if your client is sitting in a restaurant, or if they're sitting in the middle of the living room and all their family is around them. They may have to discuss things that they don't want their family to know. Encourage them to be in a private room, but again, you can only see so much. Or if you're not doing video conferencing, maybe they're only on the telephone and you don't know where they are. Maybe they're sitting in their car with a whole car full of people. You don't know. So you need to explain the limitations of teletherapy and what the challenges are and how you're best to work through them. And then document it all. Document. As an attorney that I used to work for always used to tell me concerning documentation, if you didn't document it, you didn't do it. So if you don't have anything in your notes about commenting where your client is located and what their situation is, you didn't ask the questions. So having said that, I am going to turn it over to she who knows everything about the insurance policy. And I say that because she's my resource whenever I have questions. Lonnie Ropp, take it away.
Thanks, and thanks for having me today. I really appreciate the opportunity. I've actually had the opportunity to travel to New Jersey for a couple conferences, and always enjoyed speaking with the group there. Just an amazing group of people. I'm Lonnie Ropp. I'm the Director of Product Management for the NASW Risk Retention Group. And being a part of the Risk Retention Group, we actually support your liability insurance products. And especially since a lot of our client, or a lot of your client contact is emerging and changing on a regular basis, there are a lot of questions coming up as to, will I be supported if one of the folks that I'm working with would bring allegations against me now that I'm in this new normal of communication and working with them? And a lot of the stage that was set before I came on with Betsy and Dina is the fact that they set the stage for their requirements around it, and I actually help to make sure that if the professional liability policy is needed after all of those great pointers are exhausted, that it's there for you and that the coverage is provided for your use if it would be within our contract. And one of the biggest questions that have come up recently is, are these new services in this new venue covered? Well, I should share with you, I use the term covered very carefully from the vantage point that on your contract, you have coverage, but it's subject to a couple caveats that we call exclusions. And the same exclusions actually apply to your, the way that you're talking to clients via teleconference, that they would in an in-person meeting. So if you're meeting with somebody in person or via teleconference, you've already done the due diligence to make sure that you're well prepared from a regulatory standpoint to be in compliance. So the policy will respond just like it does for an in-person consult. And when I talk about exclusions or caveats, probably one example that I'll give you just so you can realize that there's like no insurmountable pitfall out there. A good example of an exclusion would be that the coverage on the policy would not apply to somebody where their license is suspended or revoked. So if they had to have a license to provide those services, that if your license is suspended or revoked and you're still providing that care, that we wouldn't be able to help you out in that instance. And that makes sense because you wouldn't do that whether you're meeting with somebody in person or via telemental health services. So just wanted to use that example. So with the NASW risk retention group liability policy, we're there, and we are there just like you're meeting with clients on a regular basis. But just like what we covered already today in this communication, all insurance or all social workers are the world's best risk managers. And in my experience, spending a lot of time in the insurance business, I'm always pleased and appreciate the fact that our social workers on a nationwide basis reach out to us and say, you know, I'm going to ask the question before I proceed. And that's one of the professional behaviors that keep the profession the amazing jewel and that it is. And I just really appreciate the opportunity to work with professionals that take their efforts so seriously. And I should point back to something that Betsy had shared about self-care. A lot of errors can happen if you're not doing that self-care. And I see evidence of that through, you know, circumstances that I hear about periodically. Do care for yourself, not just from a professional liability standpoint, but just knowing that everything that you do is amazing and is just as amazing when you care for yourself first. But I do appreciate the opportunity again to be here today. Probably one or two words that I keep hearing during this time frame is that we're better together. And I don't know where I heard it. It's not something I came up with, but it's something that I firmly believe. And in being able to professionally work from home to support this profession with our liability products, I do appreciate that opportunity to be better together no matter where we are. So thank you for the opportunity for my opening comments, and I look forward to our questions.
Great, thank you all so much for that information. I do want to remind everyone, in the chat box, please be sure that you're sending the message to all panelists and attendees. If you just send it to all panelists, only we can see it, unfortunately not everyone else. So please be sure to do that if you want everyone to see your comment. And keep those questions coming. We've had a lot of really amazing questions already. And the first one that I saw came in is someone was asking, is it okay for the client to scan or email the consent paper form back to the therapist or take a picture with their phone and send it to the therapist?
I'll jump in on that one. Yes, I think it's okay to have it scanned and sent back. At some point, I would strongly urge you to have the original signature document back with your file. You may think, oh, it's no big deal. I have a signed copy, but I've been working with professional liability claims and risk for about 25 years now. And I've seen a lot of lawsuits over that time. And the record is the most important thing that you have. And having that original signature, it's really hard for a person to deny that they said it or they signed it or someone else signed it for them, or it's a fake, it's just a photocopy, whatever. If you can get that original signature back, please do so. I think it'd be fine to have the scanned copy back temporarily, but make arrangements to get the original document.
Great, thank you. I'm seeing a lot of questions about what the rules are for each individual state. Unfortunately, we are not all experts in what all 50 states' licensing regulations and rules are. However, I see everyone's answering each other's questions, but also your local chapter of the NASW is an amazing resource because they know their own laws and regulations for that state. So I would implore you, if you're curious, if your client's in another state, first check that NASW chapter and see what they have to say, because they probably have updated some information about what is the rules for there. The next question that I'm seeing.
I would like to add something.
Yeah.
The other hard part that Dina sort of referred to a little earlier is that states are making all kinds of temporary changes during this coronavirus period. And if you look at them, they may have an end date, but then the end dates keep moving. For example, we were on stay-at-home through April. Now we're at stay-at-home through June 4th. That kind of stuff is changing all the time, which makes it difficult for practitioners. So it's important that you stay in touch with what is happening to your state licensure regulations, because they're a moving target right now.
To follow up behind Betsy and Annie as well, get in touch with your local NASW chapter. Absolutely, they will be trying to stay on top of these requirements. Get in touch with your state licensing board. If you try and reach out to find out what the current state law is, you'll get lost in the marsh very quickly. The licensing board, the NASW chapter, should have the most current information for your state, or for another state if you have a client that's stranded and you're trying to help them as best you can. You need to find out if you can get a temporary license there, or if it's even possible for you to care for your client based on your license. All of that information, go to your NASW chapter or the licensing board.
Just to circle back on that from a liability insurance program standpoint, make sure that when you are verifying regulations, state regulations surrounding the provision of your services, please note that an insurance program representative is not going to be well versed and will in fact hesitate to share your state regulation with you, because it is a 50 state there's 50 separate laws in 50 separate states to be mindful of. And just like Annie shared, your NASW, it's the power of a professional association. Your NASW chapter may be able to point you to those resources. But I suggest that you definitely note that even if a colleague shares what regulation is, still just go back into the regulation and touch it and feel it for yourself, only for the purposes of your own protection. And please note that that's something that should be directed. And if you have a question, you don't want to ask a regulatory question for somebody who isn't in the field. So like an insurance representative can't answer a regulatory question even if they're looking at the law, because they can't interpret the law. So your social work board of examiners is also the exact point of contact that would be able to decipher that for you, where actually an insurance representative, even myself, would be out of scope in interpreting that. So just that, I just measure that to be careful.
Thank you for that. Another question relating to informed consent. Someone was saying that they're a government contractor and their employer is telling them that oral consent is sufficient and they are not requiring a hard copy of the client signing any document, and they're not comfortable with this, and so they're just curious, is that okay? How do they navigate that situation?
I'll jump on that one. That their employer may tell them that, oh yeah, it's fine to just have an oral consent form. For your own comfort, if you're not comfortable with just oral, please get a signed one. I would just as soon have a piece of paper in your file, because it's very hard to defend that you had proper consent if you don't have that piece of paper. If all you're working from is oral consent, even if you have documented in your chart client confirmed verbally that they agree to participate by telehealth, if it gets down to litigation or a board complaint or anything like that later, you're going to wind up in a he said, she said situation where the client says, no, I never agreed to do this. I would never have agreed to do this. And you say, but yes, you did because it's in my notes. Who's somebody going to believe? Get the piece of paper. It's just a little extra confirmation.
Great, thank you. Another question is, how often should these informed consent forms be signed? Is it yearly, or is it just when a new case is opening? Betsy, I think you're muted.
Yep, Betsy's still on mute.
There we go. I got it finally. We recommend that you annually redo your informed consent process. Go through things once a year to make sure. Also, if in the event there's some kind of change that occurs during the course of that year, like you go from doing face-to-face to telehealth, or you move offices, or something changes in your practice, it's important to then redo that informed consent. I know it seems a little maybe obsessive compulsive, but it protects you and the client, and that's what's really important. It helps remind the client about what you're doing, why you're doing it, what are the limitations of confidentiality, those kinds of things. And at the same time, it protects you from any later kind of accusation that someone wasn't informed about something. So think about it that way, kind of an annual redo, like taxes maybe, or and anytime you make a change in the way you're doing your practice.
I'd also chime in behind Betsy that say this is also a really good time to reconfirm who the emergency contact is for your client, who they would allow you to speak with if an emergency comes up, if there is a concern that needs to be shared. That's the time to make sure that you have someone on file that you can speak with in an emergency.
Great. The next question is, how does paperwork getting lost in the mail impact their liability regarding confidentiality?
I can answer that. Keep in mind, lost in the mail. I guess I'd probably need to know a little bit more about it, but overall, as far as HIPAA violations, there are some circumstances that are beyond your control, and sometimes the mail itself is a good example of one of them. So essentially, if that paperwork would find it's in the wrong place, and it was not something that you intended, there is coverage on the professional liability policy that can be explored for assistance in notifying clients to be able to provide the appropriate notifications. Essentially, the biggest duty there is to notify those affected. There would be support for that. If it ballooned into something else, that would be something for our claims adjudication team to evaluate from a liability standpoint. And if fitting within the contract, go ahead and pursue additional avenues of contractual support. So it just really depends on the circumstances. And of course, anytime you have electronic commerce, e-commerce, email, or anything, or even in, snail mail, and I don't even know if that's the right term for it, so I apologize in advance if I use that incorrectly. But basically, all of those ways of operating has protections within the policy to support you from a liability standpoint if somebody indicated that you were problematic in that. But definitely give us the opportunity to evaluate everything on a case-by-case basis. And once we know the, down and dirty of every piece of information, we'll be able to pursue the best next steps on your behalf.
To add to that, I've been aware of some social workers who've been sending those out by certified mail so they can document that it went to a particular person. It seems to me that in that situation where it's lost, I would toss the ball to somebody who knows way more about HIPAA regulations than I do. I don't know whether that would be considered a breach. I would find out if it was a breach so that I could follow through appropriately and not be held accountable for not following HIPAA regulations.
Chime in behind Betsy with that. Yes, it could be considered a breach given what may be on the piece of paper that was lost in the mail. As Lonnie said, submit it to NASW, let us look it over. Call the hotline, we'll talk through it. You always also have the right to consult an attorney in your area and say, hey, is this a HIPAA breach? What do I need to do? We've got lots of resources available through NASW to help you go through this and what you need to do if it is determined to be a breach, how to report it.
Great. So going along with HIPAA compliance, New Jersey in particular, other states may have done this as well, has waived some of their HIPAA regulations in terms of allowing practitioners to use things like FaceTime or Skype as a way to be more accessible. How does that work with their liability insurance, considering that, the state is waiving it, but that's not necessarily what their liability, they agreed with this liability insurance to cover them to act in a HIPAA compliant way. So just curious your thoughts on that.
Yeah, Dina, do you mind chiming in on that one first?
It depends. How's that for an answer? You need to be careful whenever you're using FaceTime or Zoom or Doxy, I think is the other one that I've heard used. Any of these web-based portals. You want to make sure that you have a secure connection. You want to make sure that everybody involved understands the limitations and what can possibly happen. Again, that goes back to your informed consent practice. And if you have done the best you can to make everything secure and have that secure communication, I think you're okay. You don't want to be la-di-da about this. We're still talking about therapy. You're still talking with a client about confidential things. Be concerned about possible breaches. Just because the state has waived the requirement, as we said, we don't know when they're going to take back that waiver. And so you want to always be very cautious. Act like there's no waiver in place is probably my best suggestion. Lonnie, anything else to add?
Yeah, and actually on the tail end is, my first thought was put the efforts in place as if this state of emergency didn't exist, in terms of being aligned with the technology standards, being aligned with the facets of the NASW Code of Ethics. Lay the groundwork as if this was your daily mission on a daily basis regarding the state of emergency. That was the first thought that I had. And then I was like, because the interesting thing about regulation and waivers and whatnot, sometimes it's interpreted that it applies to more things than it does. So that's why I just always say, operate as if, you're in tune with all of the resources that you had before today's happened. So even if you don't have to do a Zoom with your client going forward, you're prepared to regardless. And so I think that was a good point, Dina, and you brought it home for me, because that was my first thought.
Thank you. Another follow-up question to that is, So somebody gets a temporary license for Florida and starts seeing clients telehealth in Florida. Does their malpractice insurance cover them? What is the liability with practicing outside of their state?
Yes, essentially they've laid the groundwork for being in adherence for state regulation, and they've done everything a prudent professional could do to make sure that they aligned with the state that they're providing services in. So that's one. One thing I wanted to point out as far as the way coverage works and regulation is essentially, let's say there's a state law in the books that they weren't aware of, and this is why you want to investigate it in a comprehensive way in advance, is because essentially our policy is there to support you. But when you have a state law out there and we're coming in to try and help mitigate the outcomes of an allegation that's before you, we can only defend as much as we can against that state law, because state law is state law. And to be able to overcome the penalties associated with different regulations, it's obviously we would do our best laid efforts, but on the flip side though, we may not be successful because it's in fact state regulation. That's why we do caution folks to do that due diligence in advance, because we don't want to have to set your expectations that it may not be a good outcome as far as coverage support is concerned. So that's actually a good question. I did want to take the opportunity to say that we really are anxious to support social workers, but that due diligence is extremely important, and that's why.
Also, Andy, just to chime in one last thing, if you have a temporary license, for example, like you just said, you have a temporary license in Florida, please make sure you understand when that license stops. It's not going to go on forever. You're not going to have it forever. Please make sure you stay on top of that. You don't want to get caught sideways with a state licensing board.
Now, should you inform your malpractice insurance that you have temporary licensure in another state?
It's not necessary, as long as that temporary license, it would sufficiently address the type of services that they're providing.
Okay. So someone else had asked, there's a lot more about informed consent, I think, in terms of getting electronic signatures. And I know we had said best practice is to get a physical copy at some point, but a lot of people have questions about the practicality of electronic signatures. And additionally, someone said that their employer is using an opt-out letter. The letter is sent home that says students may participate in virtual services unless the parent notifies them that they don't want services. Does this cover a social worker legally?
I think it would, as long as the social worker has that letter, that signed letter, in their file. Don't go on the student saying, my parents said I don't have to do this, because teenagers lie. Some of them tell the truth, but some of them don't. So if you're going to depend on the language in a letter, have the letter in your file.
I would just add that you need to make sure that the parents understand that virtual services could include therapeutic interventions. Because now all the students are at home and they're getting all their classwork at home. And if the parent's only thinking of classwork and you're going to be talking to the student for some other kind of purpose because they aren't sending in their whatever as a school social worker you might be doing, or in whatever agency it is, make sure that if they're opting out, they understand that that could be part of the service. I would want to see the letter they're opting out of and make sure that what I do was listed there before I accepted that as my final informed consent in my file.
Another question about liability insurance is just someone was saying they're starting as an ICU position in a hospital. Do they need liability insurance, even if it's not private practice?
When they say ICU, so they, just to clarify, and Annie, you could probably do this, an ICU work as a social worker?
Yes, assuming they're doing licensed work in a hospital.
Okay. Do they need it? Now keep in mind, obviously there are liability forces from within their employment situation. I have found several circumstances, but not all the time, but several circumstances where a social worker or being a licensed person can actually have an experience in the workplace where they could potentially be reported to the licensing board, and the nature of the report could have stemmed from the employment location, or could have been from the employer itself, only because there are certain violations that employers, depending on their funding circumstances, have to report. And sometimes it is not, those violations are not always mitigated in an employment internal investigation. A lot of times some of them are going out and being publicly available. Those circumstances, though, if you're actually reported by your employer, you're in a situation where they're not going to provide a liability lawyer for you. So that would be one circumstance where I've seen where our policy, depending on the circumstances, would have been instrumental in supporting the liability aspect. And keep in mind, if you're a W-2 employee, given that you have that umbrella of other incident protection through the employer, your rate, if you did have our policy, is a lot smaller as a W-2 employee because your risk opportunities or reports would be lower in number. So I do suggest it from the vantage point that it gives you more coverage than is currently available, but keep in mind the best laid plans of your employer is to protect you for incidents, but just not all of them are, is basically what I'm saying.
I want to add to that, because I know that many social workers work for government agencies, different kinds of agencies, that when you're hired, you're told that you're covered. It's very important before you accept that you understand what that coverage is for. And I can give you an example about that. I have a friend and colleague who worked for a large state agency in their Medicare area. She is a licensed social worker. She has the liability insurance through our product with insurance services. And they had a large lawsuit regarding a decision that she was part of. So the agency was sued and individuals were sued. And this went on for quite a while. And at a point, the insurance for the agency said, this is enough, we're not paying for any more. Had she not had the other insurance policy, she would have been out many, many thousands of dollars for lawyers' fees. So keep in mind that because they say you're covered, there will be limitations to that coverage. And for social workers working in child welfare, that limitation usually has to do with if they did something that was outside of the policies and regulations of the agency, which could include something as simple as you have a caseload of 40 clients and you missed what is normally a deadline for constructing some kind of plan. So it's not as simple as the agency saying you're covered. So for your own protection, find out what they cover and under what circumstances they would not cover you.
Just to bump in right behind Betsy on that, I've actually spoken with a social worker who was very grateful that she was a school social worker, and she was very grateful that she had purchased separate coverage because there wound up being litigation against the school, and she did not feel that the school's attorney was supporting her or taking her concerns about the challenges in the case as seriously as she thought they should be. And so she reached out to NASW for an attorney to be assigned to her so that she knew somebody had her back. And I don't think it's ever a bad idea.
Thank you. I think that was very helpful. So we've spoken a lot about how licenses, all these temporary licenses are temporary, and being very aware of when these temporary licenses end. I was wondering if you could speak a little bit more about how social workers should navigate ending care, because at some point there will be potentially abandonment, there will be a continuity of care that needs to happen. So how can they do that and mitigate risk for themselves?
For me starting, and I'm sure Betsy has the clinical piece of this, for the risk management piece, make sure that if you are treating somebody under a temporary license, you've got a client who's stranded in Florida. Talk to them. This is part of your informed consent conversation. Talk to them about, up front, okay, this is a temporary license. When this is lifted, I'm going to have to stop. We're going to make sure that you've got resources available, but set the expectations up front is the best advice that I can give. Betsy, I'm sure you have many more words of wisdom than I do.
Well, that's excellent advice. It's very important that they understand that you can't continue indefinitely. And what's been difficult about our current pandemic is that it's a moving target, as we all know. So that's very good advice. But secondly, you should be, long before your temporary license comes out, constructing resources in the other location, if it's Florida, for any kind of emergency response that you might need. If your client becomes suicidal, what are you going to do with them when you're in New Jersey and they're in Florida? So you should, from the very beginning, begin to garner resources, whatever the local mental health agency is, how they would handle it. If there are private providers that might be better for you, to already have that established long before a temporary license would expire, because you're still responsible for providing services to that client in those emergency situations. And that's true for all kinds of telehealth. The farther the distance, the more difficult it is. So make sure that you're doing that as part of your practice routinely.
Sorry, I had some trouble unmuting myself. So that answers that question. Bringing it back to HIPAA compliance and navigating risk with making sure that you're being HIPAA compliant, we had a few questions about how to mitigate risk when you're communicating electronically via email. Some clients prefer texting, and even before COVID-19, I think social workers have seen other social workers using non-HIPAA compliant things like email. So just what is the best practice? How do we navigate that now that electronic communication is really our only way of communicating?
Best practice, and I'm sure Lonnie will chime in if I miss anything. Best practice is to try and be prepared in advance. I realize that we've been dumped into this and you didn't have a lot of time to ease into this and do some homework. Where possible, you want to have secure transmission. If you're sending by email, send a secure email. There are secure texting platforms out there. I don't know how readily available they are or what the cost is, but I do know that they are out there because hospitals are required to use those as well. You want to have a conversation with your wireless provider or your internet provider. I need to be doing this. I'm doing telehealth services, and I need to make sure I'm secure as possible. What do I need to do? What services do I need to have? What platform do I need to work from? What is the best? Talk to your colleagues. Some of your colleagues may have done the work. They may have started the process, so you can then dig in a little deeper from where they've taken off. This is a time to share your wisdom. If you know of a platform that's very secure, share it. But still, as part of that initial conversation at the beginning, make sure you understand, or your client understands, that even though you've done everything you know to do to make sure that your communications are secure, make sure that they understand that there are still creative people out there who are hacking. Zoom is rather famous right now for being hackable, and people jump in and out of meetings when you don't know they're there. So just do the best you can, but make sure that your client understands, yes, there are limitations, and you can only control your half. You can't control what's going on the client's end. So the client may not have a secure portal or a secure line. Just, you got to do the best you can and make sure the client understands. Lonnie, anything to add?
Yeah, and the reason I unmuted myself was I was like, I know Dina's the queen on this answer. But probably the one thing that I would say is don't be willing to go to too many different locations to yield the same result, meaning do what you can manage and manage well, especially for documentation purposes. And when I say do what you can manage well from a HIPAA standpoint, do that research. Find those core few products that you know that when you read that agreement, they're not sharing your experiences elsewhere. So a lot of those agreements, we all click through them too fast, but please don't hesitate to read them and read contracts in detail. If a salesperson says, yes, this is HIPAA compliant, before you sign that contract and before you use that modality, still read that contract to make sure that there's no caveats in there.
Again, I just want to say this again, and I'm sorry about being so repetitive, but it's very important to put into your informed consent that you cannot guarantee that electronic communication is totally confidential because of these kinds of things you're talking about. Also, remember to consider this with your record storage as well, because records can be hacked also. We've also had a situation with a social worker not terribly long ago where her record storage provider decided they weren't going to do it anymore. And she had 2 weeks to move, 20 years of records to someplace safe. So these kinds of things, the landscape is changing entirely too quickly for any one person to know all of the platforms and how they work and if they're secure. So it's really important you do your homework.
Now, this question's come up a few times, and forgive me if we've already gone over it a bit, but I think it is important to reiterate. Does standard liability malpractice insurance cover telehealth? Do people need to add something additionally if this is going to become long-term, or is it okay now because it's temporary?
Just like you do in-person consults, the professional liability insurance policy is there in case your clients have indicated problems with you professionally. Much like, or just like that, teleconferencing and the different venues that you have to use now is covered as well. There's no need to endorse your policy or increase anything that you wouldn't have otherwise increased. On the policy, it's there to support you. Keep in mind, and this is just because I'm an insurance nerd, I have to share it, that all client contact, whether it be through telecommuting or I'm going to call it telecommuting, but through mental health devices or in an in-person visit, you're subject to a very few exclusions in the way back of the policy. And one example I gave at the beginning was we have the right not to cover the service delivery of somebody where their license is suspended or revoked. So things of that nature, you always want to review the exclusions, but you'll find that when you review the exclusions, that none of them refer anything to the modality of how you work with your clients, just that this policy is here to support you in case they professionally, they have a professional disagreement with your services.
We also have a cyber policy. Could you talk a little bit about that and what that covers, Lonnie?
Yes, as a matter of fact, and actually we were just talking about HIPAA violations. Now, one of the classic HIPAA violations that is supported on your professional liability policy is when you're responsible for that HIPAA violation. Like you send it to your email group at you know, your mom's group or something by accident, or your dad's group by accident. You sent an email with private client data by accident. You did it. It was an accident. We can handle that within the professional liability policy. We do also offer a cyber liability policy. And that cyber liability policy is instrumental for those incidents that are beyond your control. An example of that is the security hack or a hacking incident, where you're in a Zoom meeting, you paid for the HIPAA compliant version, you've done everything that you can to ensure that that agreement ensured your confidentiality with the person, and then you find out later that that session is being held for ransom or something. And I'm just giving you a random example, so please understand that this isn't a tried and true in every case, but basically you're not responsible if Zoom gets hacked during your client contact when you've done everything that you can to ensure that HIPAA incident. However, because you're not responsible for it and it happened through that device, that cyber liability policy covers what we call third-party liability, meaning you can't control it, but because you use a device and have to continue your business operations in something that that your hands can't always ensure that situation to be firm. So that hacking incident would gain HIPAA coverage and support under the cyber liability policy because it's a third-party provider that was the cause of that failure. It wasn't you, because you've done everything you can. So we would, under that policy, respond to notification costs, notifying your clients, and if something would arise related to the liabilities associated with that breach that of course you had no purview over, you would be supported within the confines of the limits and coverage under that policy. So that is a good resource, especially if you're not working with an employer platform. A lot of times employer platforms may have cyber liability coverage intact for them, and thus in your use may have coverage, but it's still always good to have your own support in case maybe even your internet got hacked. So you can check online. The resources at the end of our presentation will take you to our NASW-assurance.org site, and those products are detailed and provided for your review if you'd like to consider them.
One more thing that I wanted to jump in just on coverage for telehealth. There is coverage for telehealth, obviously, as Lonnie just said, but that coverage is assuming that you are licensed in the state where the person is. And this is something I have had long discussions with social workers about this. And it's all about location. Where the phone is located is where the coverage needs to be. So again, we're going to go with you're licensed in New Jersey and you have temporary in Florida. You're fine to talk to a client in Florida. But if the client decided to drive north to South Carolina to see the tornado damage or the hurricane damage or whatever it was that dropped in there, and they call to talk to you because now all of a sudden they're upset, you're not covered for that call because that client is in South Carolina. So be careful. Be very careful. That's where it goes back to, you have to know where your client is located when you talk to them. Okay?
Thank you for that. So obviously for informed consent, we want written consent is best practice, but what about release of information? Is that also needed to be in a written form, or can verbal permission be given to release information to doctors, schools, parents, etc.?
I prefer written, always.
Yeah.
The same with a consent. I don't know if Betsy has a different thought about that, but I always prefer to have it in writing.
I know we sound like we're being really harsh. I get that, and I know it's not always convenient, but when you see the kinds of things that have happened to social workers when things are missing from their file, and they really didn't do anything wrong, and they still are held accountable, you begin to see the importance of being a little bit compulsive about keeping those records. That it's important to protect you, and it's important to me that you be protected so you can do the kind of work you want to do.
Great. I've seen a lot of questions about how to conduct group therapy via telehealth. And while I did state we're not really discussing clinical strategies for how to do those things, we do have a lot of other webinars that did address this on our COVID-19 resources page, which I will be sending out again to everybody after this is done. But I would love to talk a bit about just the idea of, similar to what we're doing, social workers really want to try and provide some support, some psychoeducation, some for people, through a Zoom meeting or in an online platform. How does that work with their license? Are they able to provide a support group, through a Zoom meeting, or, with people who may be across the country, or how should they try and proceed with that in a way that they can still support people but not risk their license?
Well, I'm gonna parrot Betsy here. Informed consent. If you want to have a Zoom group meeting, you need to have consent from everybody who participates. If one person does not want to be in the group, then tell them, okay, don't dial in. I'll talk to you separately. As long as everybody who's participating has agreed, yes, I agree that we can discuss coping techniques or whatever, and it's not intended to be a specific individual session. Set the expectations up front. Share that, we're not here to do individual therapy. We'll do that separately, but this is a group thing about how we can best deal. I don't see a problem with it. Be careful though, set the expectations and get that informed consent.
It's really important to protect your license that you're clear. What I heard was something a little bit different than I think Dina's talking about. I heard the question was, what if you just want to do a support group? You're not doing therapy. You're just talking to people and letting them share their experiences during the pandemic, that kind of thing. And it's just a support group. You need to make very clear in that informed consent that this is not intended to be any kind of therapeutic group, because that would be the point at which your license could be in trouble, particularly if you're having people from across state lines coming into the group just to talk. And I would also take one other step, and I would check what the regulations are in my state. If they make Many states make a distinct difference between, they'll either call it psychotherapy or therapeutic groups versus educational support group kinds of things, and they call them all kinds of different things. If your state makes that distinction, and then you also take this extra step of getting, a consent that makes it really clear you're not doing therapy, then you shouldn't have a problem. If, however, your state says people who are licensed are always practicing therapy, I'd be very cautious about doing anything like that outside of where I'm licensed to practice.
Great, thank you. So we do have, about 20 more minutes. If anybody has a question that they would like to ask live, via audio, please raise your hand. There should be a button that allows you to raise your hand, and I can bring you on and unmute you so that you can ask your question live. So if anybody's interested in doing that and participating in the conversation. Oh yes, I see Laura. Laura, I'm gonna bring you on. You should be able to unmute yourself, Laura.
Can you hear me?
Yes.
Hi, I'm Laura. Nice to speak with all of you. Thank you first for doing this. This is so important, and I'm just so happy that I was able to participate in this, and I've already learned so much, so thank you. So my question is, I know we've been talking about, HIPAA compliance and security. The only thing that I typically will email clients, I'm in private practice, is confirmations of appointments. Does that require a secure email? Just saying, hi, Jane, just confirming tonight at 6 o'clock. Thank you.
Out of an abundance of caution, I would say yes, just in case you send it to the wrong person. I've had that happen with texting. I've spoken with several social workers on the risk management hotline where they clicked the wrong contact and confirmed. That could be considered a HIPAA breach because you confirmed that this person is one of your clients. That could be considered a HIPAA breach. I tend to go extremely conservative in what I consider a HIPAA breach. I would rather consider it a breach and be wrong than say, oh, no, it's no big deal. Don't worry about that, when it truly is. I'm a cautious person. I would say, yes, it should be secure. Betsy, what do you think?
I don't disagree with that, but I would add, at a minimum, I would make sure it was encrypted.
Okay.
If you send something, really make sure that it's encrypted. And there are people who are using emails and texts, particularly for the kind of thing you're talking about, Laura. And we really, as much as you can, if you have a secure platform, by all means do that. Dina's right about being conservative regarding that, but at a minimum, make sure it's encrypted.
Okay, so I'd have to learn how to do that.
Some kind of protection. I also know people who use text to do confirmations, and their clients will text them back.
I never use texting. I'm pretty old school. Everything I have is on paper. I don't do anything online. I still send out HICFA forms. I'm pretty old school, but the email, I just figured since it was a simple, hey, just confirming, and they say yes, I just figured that was pretty safe, but I'll have to learn how to encrypt them. I don't even text, to be honest with you, and I'm not even, I'm pretty young, but I don't text. I'm just very cautious. I just thought the emails were pretty safe, but I'll learn how to encrypt them and move forward from here with that.
Check with your email provider. I don't know if you use Gmail or Outlook or
Gmail. Okay.
Check with them and find out what you need to do to encrypt an email.
Okay.
They should tell you. They may want to charge you a little money for it because that's the world we live in. But you should be able to get encryption on any email platform you use.
Thank you so much.
And sometimes if you go into the settings, it will tell you how to encrypt.
Okay, I will do that once we're done, for sure. Thank you.
Thank you so much, Laura. And also, Laura, where are you from?
New Jersey.
Oh, New Jersey. Great. Happy to. All right. So I just lowered all hands because I'm not sure when they came in, but if you want to ask a question, please raise your hand again so that way I can bring you on. All right, Linda, I see Linda immediately raised her hand. I'm going to bring you on. Linda, you should be able to unmute yourself.
Okay, I'm unmuted now. Do you hear me?
Yes.
Okay, here's my question. If I'm doing a family session and I want to know, like in New Jersey, at what age do I need to be sure that I get a consent from the child? I can't remember if it was like 12 or 13, but at what age do I have to have that child? For younger children, the parent has to consent for the child. So the other question I have is, if I'm doing a family session, do I need a parent to consent for the child that I'm working with, or all of the individual children that I'm working with in the family, and the adults also to consent, or can it all be done on one form?
Dina, do you want to take that, or you want me to take it?
Well, as I said before, I'm an abundance of caution. If you want to have one consent form, it would be perfectly fine to have every person in the room sign it, the parents signing on behalf of the children. And I don't know the age of consent off the top of my head for New Jersey. I do know that some states allow minors to consent for themselves. Some is 15, some is 16, some it is 12. So Annie, I'm going to defer to you or to someone else who can look it up quickly. I'm cautious. I would just as soon have all the signatures.
I also want to caution you, family intervention and couple intervention was not, I don't think, this is an opinion, it was not really thoroughly considered when they wrote HIPAA regulations. And here's the problem. Let's say you're seeing a family or just a couple, and those parents they decide to get divorced, and you get dragged into court for a custody hearing or something like that. And the father wants all the records from these sessions. Well, unless you keep, and you're going to hate me for this, so I'll say it ahead of time, unless you keep a separate record for both those parents and every member of a family, you have a problem when that happens. And a lot of attorneys right now are recommending that you keep separate records for every member of a family. So that would include a separate informed consent for them because of these kinds of issues. And like you, I've been a social worker for a long time, and I can attest that what happens when something goes bad, what we do is add more regulation and paperwork. And that's kind of what's happened in this venue. But I would be very cautious about how I recorded family sessions and couple sessions as a result of this kind of issue. And I'm really sorry I have to tell you that.
I agree with you. I'm between a rock and a hard place with my job because I'm what's called an MFLAC, a military family life counselor. Our work is considered extremely confidential. We are not supposed to keep any written records of anything that we do. Normally, when I'm face-to-face and I can be managing everything and I see children one-on-one, and if I do see them as a family, I make sure that it's just going to be some play therapy and I don't talk about a lot of issues. It's very, very complex, but I do. So I'm mandated to not keep any records. That's a requirement of my job for total confidentiality, so people can say anything to me. There are other programs within the military program to all the different programs. There's other places they can go, and they do keep records, but I'm not supposed to keep anything. Nobody's even supposed to know that I've met anybody. It is also cloak and dagger. It's like really, really challenging. I meet people off the base. We go at restaurants and eat and talk. It's really, really challenging. So I feel like having done it in person, you're able to spring all this and do all this and get the written consent and talk to them and say that unless there's a mandated reporting or duty to warn, everything we say is totally confidentiality. Do you understand? And I go over the limitations, and they always proceed to accept that. Sometimes I have to break the confidentiality even after they told me that because of the need. And then it's okay because I'm covered by that. So I'm really struggling going into teletherapy because of the guidelines of this specific government program that I work under, and it's under the DOD, and then it's under this special program that I'm under with the Military Family Life Counseling Program, and then it's different in all the schools as to the way they want you to conduct it in their schools. And like, the job is challenging enough right now. I think I've gained 5,000 gray hairs over how to proceed with this because I don't know. I'm like, I feel like I've got to keep records because we're doing teletherapy. I mean, it's just not going to be comfortable for me, and I think I'm going to have to just shred everything at some point. But if I ever end up going, to trial or something, if people are getting divorced and things are going on, I'm supposed to say I've never kept any records, so I don't have anything. How's that going to work for my license?
I don't know how it's going to work for your license, but having been involved in litigation for as long as I have, you're going to have somebody who's going to scream, "What do you mean you don't have records?" And what always happens, and I think Betsy has been eavesdropping on my calls with social workers over the last couple of weeks, because I talk to a lot of social workers who have gotten requests for records or subpoenas for records or whatever for family sessions or couple sessions. And she's absolutely correct. You're going to have a release from every person involved in order to release the records. And to your point, Linda, and I don't know that I have a solution for that other than to say, you better have a statement prepared that your employer mandates that you do not keep records. That's you're going to be your best protection. Because otherwise you're going to have an attorney coming at you screaming words like spoliation of evidence, and I'm going to file a board complaint because you're a lousy social worker and you don't keep records.
I see Linda went away, but Linda, I'm curious, are you only working with military families, and do they have some special exemption? And I would ask for some kind of documentation that these are the requirements because of the nature of the program, and the federal government has approved this and indemnified their employees to conduct themselves in this way. I would want that in my possession because it's so far afield of how we are taught and run our business. Good luck to you. Sounds quite challenging.
Yeah, good luck to you, Linda, and thank you for asking that question. I've been told that the age of consent in New Jersey is 14, so that should answer that question. I always keep my trusty regulations paper copy right next to me all the time so that I can check questions like this when I'm answering on the phone. We do, in the interest of time, we are just about to wrap up. We can have one more question of one more person who wants to come on. So please raise your hand if you want to just ask one last question to kind of bring us out at the end of the day. Claudia, I see that you have your hand raised. I'm going to bring you up. Claudia, you should be able to unmute now.
Can you hear me okay?
Yes, we can hear you.
Okay, well, thank you so much for such an amazing meeting online. These panelists have been very enlightening. I just asked previously, maybe it's redundant, but I got confused in regards to the cyber policy. Do we have to pay an additional amount for the cyber policy because we're doing this telehealth or not? I got a little bit confused on that.
Mm-hmm. And actually, that's a good question, Claudia. the cyber liability policy is a separate policy. If you would be worried about the possibility of a third-party security breach in relation to your services, either via telehealth. Another example, Betsy, you had mentioned earlier about document storage. So if you're worried about the document storage company not seeing through their responsibilities, and if for some reason a breach would occur because of their actions, that's not something that you would have within your care, custody, and control. So that's why that cyber liability policy affecting your operations as a social work professional may be instrumental as a coverage choice to consider. And you can actually just, even if you have your professional liability insurance policy, which is a separate policy, even if you have that coverage already, and you want to investigate and take a look at the cyber liability policy, you can purchase that or get that on our website using the NASW-assurance.org Enroll Today link.
Great, thank you so much. So we are just at about 1:30. Just want to be respectful of everyone's time. Thank you so much, Betsy, Lonnie, and Dina, and NASW Assurance Services for providing this information. And as we had said at the beginning, there's some resources that we've discussed, and I will send those out right after this to everybody who is registered. You'll get an email from me with the links to everything. And also any questions that we haven't been able to get to, I'm going to be forwarding them to these wonderful presenters right here, so that maybe we can get some of those answered and put on our COVID-19 resources page as well, so that you can all be abreast of the most up-to-date information. CEU certificates will be sent out by next Tuesday, so if you don't get it by Wednesday, you can email on Wednesday with that, but they will be emailed to the email that you registered with. Additionally, if you're looking for other CEU opportunities, NASW is having our virtual conference coming up in about 2 weeks, April 26th. It's going to be the largest virtual social work conference in the country. So we would really love to have you all with us. And we will be talking more about, COVID-19 and how we're navigating that in relation to ethics, grief, loss, working with clients. So it's really going to be a wonderful presentation. Thank you all, everybody, again, and stay safe, be well. We really appreciate all of you on the front lines, navigating this crisis and totally changing your practice and the way that you're doing your work. And I just want you all to know that we are here for you at NASW. We are continuing to provide more programming. So please stay up to date with our newsletter and our social media. And hopefully, we can continue to connect during this time. Thank you so much, everybody.